Okay, good. So I now make it 9:30. So welcome everyone to day 8 of this first inquiry session, considering the overarching issues in relation to both the compulsory purchase orders and the ROD orders supposed to be made by Transport Scotland in relation to the proposed improvements to Sheriffhall Roundabout. For the benefit of anyone who's just joining on the webcast for the first time today, I'm Katie Craggs. I'm a reporter with the Planning and Environmental Appeals Division of the Scottish Government, and I've been appointed by the Scottish Ministers to consider the proposed orders and objections to them, to hold this inquiry, and to submit a report to the Scottish Ministers, making findings in fact and recommending whether or not the orders should be made. But it is the Ministers who will make the final decision on the scheme. My colleague Callum is here again today, facilitating the hybrid session that we're doing. Dr. Boswell is joining virtually. The inquiry is also being webcast again live today. By being here, you're consenting to being filmed and to the use and storage of those images and sound recordings for various purposes, including webcasting, training purposes, keeping historical records, and making those records available to the public. So just the 2 usual housekeeping matters. Please ensure your mobile phone is switched off or on silent. And again, there's no scheduled fire alarm tests. If it's a fire, please exit by the fire exits and we'll muster in the car park. So this morning, I'm not aware of any procedural matters, so there's no late documents submitted by anyone last night. So I don't think there's any procedural matters this morning. I think we can go on. And then I'll have a few questions once Mr. Milne's completed that. So Mr. Milne, over to you.
Thank you, ma'am. Good morning, Dr. Boswell. Can you hear me?
Good morning, Mr. Milne. Yes, I can hear you clearly.
Great. So a few questions for you, and some of them will touch on legal matters which are to be developed in submission, but I'm raising them because they proceed on the basis of our factual understanding, which I am keen to clarify. So first point I want to raise with you is the 2017 EIA regulations and why you say that they apply. Now, I think it would be helpful for you to have those in front of you. This is where things got a bit complicated yesterday because there appear to be different versions lodged. The core document I am looking at is CD 002.007, specifically Regulation 12, Transitional and Savings. Can you dig that out, please?
Yeah, I'll find that. Probably still open. So was it Regulation 12 or
12?
12, and that, which page is that?
So on my PDF, as I say, this is where it fell apart yesterday. My PDF is page 29.
And right, okay, that's not what I'm seeing, actually. I mean, I've got a PDF which says it's CD 002-007. It's 208 pages in total. It was the Act amended by the regulations.
Yes, which doesn't work for these purposes. What I need us both to be looking at are the actual regulations, because the regulations are what contain the transitional provisions.
Right.
I don't know if anyone else can help by identifying another document reference number. Ma'am, I'm not sure if you've found the regulations.
I have the regulations separately.
I'm afraid my core document 2.007 are the regulations. Scotland, that means no, and that's what Dr. Oswell has, and it's not. So that's 002.001.
I download that one again off Objective Connect. Just to check. It's just possible I had that version and then labeled it manually as that number, if you see it, I mean, rather than taking it from the website. So I identify that as directly from the website.
What are you looking at? Because that's
No, for CD 002007, I've just reloaded it or downloaded it from Objective Connect, and I'm still getting the 208-page document, not the. Am I right? You're saying yours is 29 pages or in total?
35 pages is
35.
my version.
But less than 208. So
It's considerably so.
So that was CD 002007 directly from Objective Connect now. I mean, I must admit, I tend to use the web versions of these documents, so I wasn't actually looking at the PDFs till the last minute, if you see what I mean.
Yes.
Just to get the page numbers, but I don't know if that's an easier way to do it. We may better find Regulation 12 on the web.
Yes, I mean, it's a bit unconventional, but I think if you do go on to legislation.gov.uk and look for the 2017 regulations, that might save a bit of time. Obviously, we don't know what's happened, why there's a disparity between the core document bundle I have and what's on Objective Connect.
Right. Yes, I've got a web page open, which is the Road Scotland Act 1984 Environmental Impact Assessment Regulations 2007. Now, I believe that is different to what we're looking at, or what I was looking at in CD 002007. In that's the regulations itself, not the act amended by the regulations. And I think that's the point. So if I find Regulation 12. Yeah, which says transitional and savings on the content. Right, I'm on that page now.
Sorry, that's taken so much time. It's important that we're looking at the regulations. Thank you for fishing that out. So really, what I am wanting to check is, do you agree that the transitional provisions as set out in Regulation 12 are clear of the effect that the 2019 environmental statement published by the promoter are regulated by the pre-2017 EIA regulations?
I need more time to look at those transitional regulations to answer that. But
what we can do then is pick through them paragraph by paragraph. That might be a fairer way of doing this. So, are you familiar with the concept of transitional and savings provisions in legislation?
Well, some familiarity from this situation, yes.
From this situation, have you come across transitional and savings provisions in other contexts? It's a general question, not related to this scheme.
Well, I wouldn't claim to have expertise on that. It's what you're getting at.
So would you disagree with me in my explanation that the purpose of transitional and savings provisions is to provide absolute clarity as to when new regulations take effect?
Yeah.
So looking at Regulation 12.1, reading that relatively short, we see that where ministers have made a determination under certain sections of the 1984 Act prior to 16th May 2017, certain subsections continue to have effect as they did immediately before that date. Can we agree that ministers did make a determination in relation to the Sheriffhall improvement scheme under section 55A2B of the 1984 Act prior to 16th May 2017?
And this relates to the scoping, doesn't it?
Screening.
The screening. I agree that the screening was decided before the 16th of May 2017, that's never been in dispute.
That's what I wanted to check. Subsection 2 goes on to provide that certain other sections of the 1984 Act continue to have effect as they did immediately before 16th May 2017, where prior to that date, the procedure referred to in Article 5.2 of the directive was initiated. It's really just to check whether we're in agreement that that procedure referred to in the directive was indeed initiated before 16th May 2017. Are we in agreement?
I'm not quite sure what that procedure is.
That's the scoping procedure to which Ms. McClelland referred in her evidence, which she confirmed began before 16th May 2017.
Okay, I agree that was done before 16th of May 2017.
So can we agree that the effect of the transitional provisions is clear? That is, that the pre-16 May 2017 law regarding EIA and roads projects applies to the Sheriffhall scheme?
I'm not quite sure about point 2B or section 2B there, because saying prior to that date, the environmental statement prepared was published.
That's an alternative. I'm not relying upon 12.2b.
Okay, yeah. Okay, yes, I agree with that.
We agree that we are dealing with the pre-16 May 2017 law.
Yeah.
Did you understand that was the position when you prepared your expert report?
I've certainly seen the reference to that, to all those issues, particularly in chapter 6 and chapter 18, I think, possibly chapter 1 and chapter 6 of the environmental statement. I'm not sure that I fully understood that. I think it's fair to say it's become a lot clearer during the examination. And
Thank you for
the cross-examination. I had a clearer understanding after that.
Thank you. The promoter's position, of course, is that the ES was entirely clear on this matter, and the promoter's position was clearly restated throughout its overarching report. Has your position now changed through the inquiry process, as you fairly explain that your understanding has changed? Has your position now changed to one of you have a reasonable expectation that the 2017 regulations will apply, despite the fact that as a matter of law, in terms of the transitional provisions, they do not.
Yeah, I think that is the position now. That is my position now, yes. So it is a position on reasonable expectation.
Is reasonable expectation a legal concept?
I believe it can be, yes.
I'm not familiar with the concept of reasonable expectation. What's your support for putting that forward?
My support for putting that forward is as I said yesterday in my evidence in chief, that what the 2017 environmental statement did say, I mean, it said what you've outlined, and then it went on to say, in doing the transition, under the transitional arrangements, the intention was to align with the 2017 regulations. And, you know, we can go back to the points in the environmental statement which said that, but those have all come out. I'm not sure if you want to do that.
Well, I'll put a point to you. It's of relevance. We've just agreed that as a matter of law, in terms of transitional provisions, that the pre-16 May 2017 law continues to apply. You're relying upon a concept which you may develop in legal submission, perhaps, of reasonable expectation, but the promoter's position on that is one of it is, as a concept, entirely misconceived, given the terms of the transitional regulations in particular. But looking at the environmental statement, is it not entirely clear that the promoter's position on preparing the ES is that to reflect best practice and emerging requirements with the 2017 EIA regulations require new or additional assessments, these have been undertaken and reported in this ES. A summary of the additional assessments is provided in Table 6.4. So there is, and I'm quoting there from 6.3.1, which we can go to if necessary, but what the ES does is it clearly states that the transitional provisions apply, the pre-2017 law continues to apply, best practice has been followed, and it is explained what additional assessments have been set out and reported in this ES. There is no basis at all for saying that somehow the post-16 May 2017 law has been adopted. Can you take issue with any of that?
I'm not saying that the post-17 law has been adopted, but I am saying as the environmental statement, as you say, set out in, so just trying to find it, Table 6.4, summary of additional 2017 EIA regulation requirements, and set out the intention to align with those, that there's a reasonable expectation that that would have been aligned with entirely. The 2017 regulations would have been relied upon entirely.
I think the problem you have, Dr. Boswell, is that runs contrary to the law, and the environmental statement in any case simply doesn't say that.
Under the law, you have concepts like Wensbury reasonableness and so on. And I think there are, I mean, I'm not try to create a legal argument here and now, but I do believe it's arguable that there is a reasonable expectation that if the environmental statement says it's setting out to align with the 2017 regulations, that it will do that. And I'm saying that I've provided evidence in terms of the cumulative assessment of carbon emissions that it hasn't done that.
Dr. Boswell, are you giving evidence to this inquiry as an expert on matters of law?
No. So I would not, that's why I said I'm
sorry,
seeking to create in the here and now, I'm not seeking to create a legal argument, but I'm setting out what my position would be if I, or the shoe campaign or anyone else at a later date chose to consider challenging a decision on the scheme, that would be the starting place one would go to for legal advice.
Are you appearing before this inquiry to give expert evidence on matters of law?
No, I've never claimed that I am. I'm just saying that a member of the public without expertise in the law, I believe I have a reasonable expectation, I believe the public has a reasonable expectation that the 2017 regulations would have been followed, irrespective of whether there's some fine point in the law actually points to the previous version, but everything else in the environmental statement would suggest a reasonable expectation that the 27 regulations are followed. That's what I'm saying. I'm saying that as a member of the public.
Do you have any legal qualification?
I'm not saying that I have. I've never said that I have. I've never made that claim. I don't understand why you're going down this this line of questioning, actually, because I've never made that claim. I've made clear who I am from the outset.
Your report, Dr. Boswell, I mean, just as a general remark, does emblazoned across it, say law, science, policy, and throughout your... Yes?
Yeah.
Did you want to comment?
Carry on, sorry, carry on.
And throughout your report, you make some fairly serious assertions and allegations in respect of the promoter and the Scottish ministers in terms of their legal failings. You make some significant calls upon the promoter and Scottish ministers at one point to basically adjourn the inquiry. You make a number, we can go through them, of points in relation to law. That's why I was checking whether you were, as part of your expert evidence, putting forward a legal argument, but perhaps I've misunderstood your report and that's not what you were intending to do.
Well, in my report, I set out a resume which gives my professional background. I'm perfectly entitled to express views on the law as a member of the public.
Well, that's not quite
to...
right. Sorry, Dr. Boswell, are you aware of the duties of an expert before an inquiry? Because my understanding is that you are appearing in the capacity of an expert. Now,
yeah.
Are you familiar with the duties of an expert in a court or inquiry setting?
Well, I'm appearing as an expert on climate change primarily, and I'm saying that I have some knowledge of these areas. I have a view to express on legal aspects, but I'm not doing that as a lawyer, or as I'm not claiming legal qualification to do that.
Right. So I'll proceed. I'll proceed on the basis that the legal comment in your report is not expert opinion.
Yeah, that's fair enough. It's views which are expressed with some knowledge, but they're not the views of a legal expert.
The point of concern that I do have is that a witness professing to have expertise, which I had understood from your report, you were saying related to matters of science, policy, and law, is that an expert is not allowed to stray out with their area of expertise. Perhaps we've gone through that enough. Do you have direct expertise, just developing the point as to the scope of your evidence, do you have direct expertise in terms of preparing environmental impact assessment reports?
I have seen a lot of them. I haven't prepared them myself. I have a fairly detailed knowledge of the issues involved because I've looked at a lot of them.
So your expertise is gleaned from looking at the work of others?
I would say my expertise is gleaned, as you put it, from scrutinising a large number of these over many years, but particularly the last couple of years, but spanning back over a couple of decades. And I was first sort of looking at these sort of things back in about 2011 in this sort of detail. I haven't worked in a team of consultants who are preparing these reports because generally I would not be wanting to work on projects involved in high carbon infrastructure. But
do you have any relevant qualification, any relevant professional memberships in terms of the undertaking of environmental impact assessment?
I come here, as I've said, really, as a retired scientist. And I approach things from fundamentally a scientific position. I have wide knowledge of policy around climate. And I've worked on that in local authority as a councillor. I've been immersed in policy, but from global, from the UN level down to the very, very local for 20 years. And I have knowledge of the law, but I don't profess to have legal expertise. I go to others for that.
Was your report reviewed by a legally?
I'm not masquerading as anything, apart from what I say. I'm a retired scientist, and that's how I introduced myself.
Thank you. That's helpful. Was your report reviewed by a qualified lawyer?
No. I didn't think it was necessary.
Even making the serious allegations and assertions and calls for inquiries to be postponed, I think we're at that point. Can we turn to the Climate Change Scotland Act 2009 as amended? And that's CD 002.016. There are a few points that we need to take from this.
Can you give me that
so that's
again? So 002.
Yes, of course. CD 002.016.
16, right.
Specifically section 94A, please, and that's on my PDF, page 158.
Right. So which
it's in respect
PDF?
Yes, sorry. PDF. I said 158. Page 158.
Oh gosh, we've got I've got a document which has got 88 pages in it.
something has gone badly wrong with our
I've got
documents.
the same document, and I think it's page 77. Sorry, 71 of the PDF. If you go into section
It is
94A.
94A.
And it,
As long as we have the correct text, it doesn't matter.
okay, so we're on
page number.
94A. I'm there too.
Yes, so just to check, in light of the discussion that we've just had, do you stand by your call made in your expert report for the inquiry to be adjourned until section 94A has been complied with?
I think there's two levels you can look at this. A decision was made by the Scottish ministers to bring the scheme to the inquiry, and I could find the date for you, but I believe that it was before May 2022. So it might have been possible to argue within some period of that decision being made, legally in a court or something, that it shouldn't be brought forward because the section 94 hadn't been exercised. But there's also another level of whether bringing it forward was good governance, a less legal level. And
less legal, does that mean without legal basis?
Yeah. The first one was, potentially if one had known whether it would be within the 6 weeks or the 3 months period of challenge, I don't know. I haven't looked into it at that level of detail, but there might have been an opportunity if one had known that a decision had been made to challenge it. I wasn't even involved at that time, so I wasn't around then. But I'm just saying there might possibly, arguably, have been a point at which it could have been legally challenged, but that's not what I'm talking about. I'm talking about, is it good governance for the Scottish ministers to have a duty imposed upon them by the section 94A and not to have fulfilled it and then bring forward infrastructure to a planning inquiry like this one, not having discharged that duty? And I would say that you could make a case at that level that it was not good governance to do that. And again, that the public might have a legitimate expectation that the section 94A would have been
Boswell, it does sound like you're giving legal opinion again. It will not surprise you to hear, well, it's stated in the overarching report that the promoter's position is that the section 94A duty has been complied with by Scottish ministers, but the key point for this present inquiry is, well, could you, I'll put it as a question to you, can you tell me where in section 94A you find a direct express link with the consenting of individual schemes, given that section 94A is entirely to do with reporting around the publication of infrastructure investment plans?
Yeah, no, I agree that it doesn't cover individual schemes. What I was saying was that, well, first one has to note that it's 3 years since the Act went through of that order. And this duty still has not been fulfilled. And the infrastructure plan can't remember exact date that was published offhand, but that was published, and we've even had an annual progress report on it. So it's published more than a year ago, and still the duty's not been fulfilled on it. Yet schemes are coming through into planning. It's sort of cart before horse in that sense. And I'm talking, when I say the member of the public has a legitimate expectation, I'm not giving a legal view. I'm just saying that's my view as a member of the public, that the public has a legitimate expectation of that duty having been fulfilled before you start seeing the planning system looking at schemes which are in that plan. And I would say there's a case to say that's not very good governance, that it's happened that way round. The much preferred governance, due diligence, if you like, would have been to exercise the carbon assessment of the infrastructure plan within a year or so of the Act. I know there's technical difficulties, but the fact they've taken 3 years does seem very slow, given we're in a climate emergency. This isn't a joke. We're in a climate emergency. It takes 3 years to work out how to assess the infrastructure plan.
I don't think anybody would think that this is a joke at all, and I would, on behalf of Transport Scotland, take very grave exception to any suggestion that that's what ministers or Transport Scotland's attitude was.
No, but fair enough. But we are in a climate emergency. We're 3 years downstream of the Act. We have not yet got a Section 94A duty exercised on that infrastructure investment plan. And the planning system is sort of continuing to, look at this project. I don't know about others. That does not seem the right way round to me. And as
I think the point, Dr. Boswell, is exactly that. This inquiry is looking at this specific project, and I think we agreed that there is no direct express link in Section 94A between reporting arrangements around infrastructure investment plans and the consenting of individual schemes.
Well, that's why I've expressed this at 2 levels. And I've said that when the decision to bring Sheriffhall forward to this inquiry, which was made sometime before May 2022, there could possibly, arguably, been, we don't see a direct connection in the Act, but there might have been lawyers who could have found a rationality argument, or all sorts of things. I'm not a legal expert, so I don't know, but I'm also saying we've passed the time where that was possible. That is my view as a layperson, that we have passed the time. So I'm not setting out to try to legally challenge that or anything, but I am saying at another level, I still think that there's a legitimate expectation of the public that these things are done in the right way. And as time goes on, it looks increasingly that till we get that methodology, and I know that there's an institute working on it because it's in one of the documents, Fraser something Allender Institute, I think. There is an institute working on this methodology, and frankly, I just hope they get that together as soon as possible, and then we can start looking at the carbon assessment made, and then that's under scrutiny. That to see whether that's done properly. But till we're at that position, we're bringing things into public inquiries. The Scottish Government's bringing things into public inquiries without any of that having been done. It just seems the wrong way round. It doesn't seem really to be following the Act. I
have your response on that. So, and I have noted that no challenge has been taken under Section 94A. A theme that we'll develop, I suspect, as we go forward, and I'll let you know this now, is that a great number of the arguments that you're making, you're making in the wrong forum. So, working through the scheme of the Act, and hopefully we can take this very quickly, because I don't think this is contentious, but it's important that I check, because this will inform the promoter's closing, specifically its legal submission. Just a bit of a timeline, really. Are we agreed that the Climate Plan 2018, and we don't need to go to that, but for the reporter's notes, that's CD 003.066. That's 3.066. So are we agreed that that climate plan was laid before the Scottish Parliament by the Scottish ministers under Section 35 of the 2009 Act, and that that plan sets out ministers' proposals and policies for meeting their annual targets?
Can I clarify, you're not talking about the updated climate?
We'll come to that. We'll come to that. The Climate Plan 2018 is the starting point under Section 35. Yeah. Ministers' proposals and policies for meeting the annual targets.
So, yeah, we're talking about the original plan which existed before the climate update plan.
Right.
I'm just trying to clarify exactly what we're talking about.
The original plan, the key point that I'm seeking your agreement on is that that plan has a statutory basis. It's the statutory plan, a term you fairly used yesterday in your evidence in chief.
Yeah.
I understand the statutory plan.
I understand Section 35 and what that means. I'm trying to understand the timing, and I think what you're saying is that 2018 plan was, as you say, was the statutory plan under Section 35 of the 2009 Act. And I think you're going to then say, well, that was the plan which was current.
No need for you to guess what I'm about to say. We're going through a timeline point that, without labouring it, I'm wanting to take is that that's the statutory plan setting out ministers' proposals and policies.
Yeah, but both the 2018 one and then the subsequent update, which came after the 2019 Act and the net zero target, both those plans are under Section 35. And I understand what you mean about them being statutory, and it works the same way in the UK Climate Change Act, Section 12 and 13, I think. Yeah, I understand exactly what you mean by that. I agree with that.
Good. As I said, that really is not meant to be a trick question. It's just the statutory context across Scotland and the rest of the UK is important. So yes, my next point was going to be about the update. So thank you for taking us to that, and it's part of the statutory plan. The next point on which I was hoping to seek your agreement is that the Climate Change Plan update also considers the findings of the Just Transition Commission, which published its interim report in February 2020. I'll run through this short paragraph. We can do it sentence by sentence if I'm being unfair to you by giving you a block of text. The report provides information on the conclusions and view of the Commission in respect of the need for clear transition plans for all sectors, engagement, and bringing equity to the heart of climate change action. Preparatory work around the development of the Transport Just Transition Plan is underway. Now, again, that's not a quote that I'm trying to trip anyone up on. It's literally a quote from the Climate Change Plan update. So it's just to make sure that we're in agreement on what I've just set out.
You're quoting something out of the Climate Change Plan update, are you, when you say that?
Yes.
Well, I don't have, if you are, I mean, it would be useful to go to the page, I think, in that document.
So CD 003.016, the best reference I found, and the key point is about the findings of the Just Transition Commission.
Is it one? Sorry, CD 003
0.016.
Oh yes, that's the one I've got.
Now, part of my text, which came from the quote, is on page 3 of the PDF.
This is the introduction, is it?
Yes. You'll see the second paragraph.
On the
We've
left-hand
developed our
Yeah.
So that's where I was paraphrasing to some extent, but that's where I was taking that text from. So really the most important thing is we have developed our approach. This is the climate change plan update. We've developed our approach based on the advice and contributions received from the Climate Change Commission, Just Transition Commission, and it goes on, Advisory Group on Economic Recovery, Climate Emergency Response Group, Scottish Science Advisory Council, and the Sustainable Renewal Advisory Group.
Yeah, I've got that, thank you. Yeah, it does. Obviously, it does say that. You went on to quote something else, I think, about sectors and so on.
Well, that I was going to come to this later, but I perhaps can cut through a lot by, again, I don't think this will be controversial, but can we agree that what the climate change plan update did was bring in the sectoral approach about which we've heard a great deal over the past couple of days, the envelopes?
Yeah, I agree. It's set envelopes to 2032, and those are somewhere, I even quote them in my report in an appendix. I've reproduced the table. It's got those sectorial targets in the appendix and developed them through the document. I agree.
And the sectoral budgets or envelopes, I think we can agree that they the requirement for the inclusion of these envelopes in the plan was introduced by the 2019.
Yeah.
And then, again, can we agree that no legal challenge has been brought against the climate change plan or the climate change plan update?
Yeah. Not that I'm aware of.
And no, neither am I. Neither is Transport Scotland. The next point relates to LA114. It would be useful to have that in front of you because we will keep coming back to this.
Okay, I'll open it up. I'll find it. Yeah.
And it's just to make this cross-reference. In terms of significance, we have the Scottish Annex S/1.4.
Right. And I think that's around page 33, was it? Yeah. Yeah, I've got that.
And we see that under significance criteria, this DMRB guidance says, following the assessment of a project's greenhouse gas emissions using the criteria in LA114, the relevant carbon budget shall be assessed against the emission envelopes within the Scottish Government climate change plan. So again, it's a straightforward question just to check that we agree that this reference in LA114 to emission envelopes within the Scottish Government's climate change plan is a reference to the envelopes we've just been discussing in the update.
No, I agree with that. Yeah.
A simple point, and the envelopes were brought in as a statutory requirement in terms of the 2019 Act.
Yeah.
And we agreed that as part of its sensitivity testing, the promoter reviewed the proposed scheme's emissions against these emission envelopes.
Well, I think the starting place is the 2019 environmental statement. And as I understand it, Mr. Lansborough said that the one and only assessment done is in I think it's table 1817 in that. This is for operation emissions. There's construction emissions table as well. So
Dr. Boswell, just
Yeah.
to save time, my question related to the promoter's sensitivity testing.
Yeah, so there was a sensitivity test done, and there is that assessment too in the further information report. That was the chosen study area, assessment 2. And I can't remember exact wording you used, but it reviewed it, so to speak, against the 2019 legislation and those envelopes. It was against the envelopes: industrial envelope for construction, transport envelope for the operation emissions. I agree there's information about that. I understand from what Mr. Lansborough said is that's not the assessment itself, it's a review of the assessment which was previously done in the 2019 environmental statement under the previous legislation.
Yes, there is certainly a time sequence here, but that information that we're discussing, the sensitivity testing, is formal information before this inquiry. You have referred to in your evidence moving on to the rest of the UK to the net zero strategy.
Yeah.
And you've produced that as issue 6.19. Now, I wasn't going to go to that document, but you've largely covered this already, but I just wanted to check that we agree that this is the plan which was presented to the Westminster Parliament by the Secretary of State pursuant to Section 14 of the Climate Change Act 2008. Are we agreed on that? I think we are, because I think you touched on that earlier. I want to be put to you as a question.
I said 12 and 13 from memory, but yeah, if it's Section 14, yes, exactly. That is the equivalent document under Section 14 of the UK Act, as you have in Scotland under Section 35.
Yes, that's how I read it as well. Section 14 refers to the Secretary of State's proposals and policies, whereas Section 35 of the Scottish Act refers to Scottish ministers' proposals and policies, both in respect of meeting carbon budgets. You refer to the NPSNN.
Oh, yes.
Which is CD 003.064. Might be helpful to have that in front of us, because I don't think we've opened that over the past 7 and a bit days. So 3.064.
Right, I might open up my own local version rather than go to.
Yes.
But I think it should be the same. We'll check the number of PDF pages. So I know I can find it quickly. Right, I've got open a document. It's got 106 pages in it.
Yes, lengthy. But fortunately, I was just going to head to paragraph 1.1. With reference to that paragraph, can you please tell me what the relevance of the NPSNN is to the Sheriffhall scheme?
Right, so 1.1 on PDF page 7. Yeah. Well, I think where you're going, and just probably to speed things up, is that it is a national policy statement which would be invoked, so to speak, by the Planning Act 2008, and we're under a different system of planning. So just to, I agree that it's not brought in as legally into the Sheriffhall inquiry. I think that's probably the answer you want. I've mentioned it in past.
I'm not really wanting any particular answers. I'm looking for your evidence, and just wanting to check that there isn't a dispute between parties, that we don't have nationally significant infrastructure projects or this type of national policy statement in Scotland.
Yeah, entirely correct. I mean, I have brought that in passing, I think. It has similar tests to, well, it has a test on carbon at section 518, in fact, 5.18 in it, which sort of is similar. I don't think I brought it in apart from in passing.
I asked because you mentioned it, but by name, I think at paragraph 24 of your report, and it was just for that reason, it was a reference to it.
Yeah.
I don't think we need to dwell on this specifically.
Yeah.
Small point. So turning now to the greenhouse gas study area, and I want to check whether you have a proper understanding of the promoter's position regarding the greenhouse gas study area. So during the re-examination of Mr. Elliott, you raised the question of the definition of the local air quality study area and the road user greenhouse gas study area.
Mm-hmm.
We spent a lot of time going through that evidence.
Mm.
Is your position that the road user greenhouse gas study area in the environmental statement 2019 assessment is based on the local air quality study area used in that assessment as defined by the criteria set out in paragraph 3.12 of HA207? Very happy to repeat that sentence. It was long.
Yeah. Well, my understanding is that is what has been said about that study area in the further information report.
Well, that's not the promoter's position at all. The local air quality assessment reported in the ES was based on the local air quality assessment reported in the environmental statement was based on the local air quality screening criteria set out in paragraph 3.12 of HA207.
Right.
The road user greenhouse gas study area in the ES was not based on the local air quality criteria. So if I can take you to develop this point to the further information, the sensitivity testing report, page 182.
I done there.
No.
So you were looking at what it says under assessment 1, probably 2.2, eh?
That's right.
Yeah.
So as set out in paragraph 2.2 of Annex 1 of Appendix H, which is what we're looking at in the sensitivity testing, the road user greenhouse gas study area in the ES was based on the regional air quality criteria set out in paragraph 3.20 of HA207. Do you understand that?
Yeah. I'm not saying that the air quality study area was the same as the greenhouse gas study area. And I understand you're saying, and I agree, that that's the regional criteria. I'm saying,
So can we,
well,
go on. Right. Well, can we agree that at the time of the ES, there was no guidance available on the determination of the study area for a road user greenhouse gas study area. And in the absence of that guidance, the promoter fell back to HA207, regional air quality criteria, which we've been just discussing. And since the undertaking of the ES, DMRB HA207 was withdrawn and replaced with LA105, which again, we've been spending some time looking at.
Yeah.
Good. And are we agreed that LA105 dropped the requirement for the regional assessment and therefore did not include the regional air quality criteria? Are we agreed that the only screening criteria this is set out in LA105 is appropriate now for local air quality only and not road user greenhouse gas?
Yes, I agree that.
So, thank you. DMRB LA105, the promoter's position, therefore, has no relationship with LA114. At the time of the further information report assessment, guidance on road user greenhouse gas study area was now available, and we looked at DMRB LA114, which provides the definition at 3.9 of the operational road user greenhouse gas emissions, the study area being consistent with the affected road network defined in the project's road model. And you may be pleased to hear that I wasn't intending to take us back through that discussion about what's meant by affected road network. I think we have parties' respective evidence on that. Now I want to turn to AIMA.
Right.
Or rather to significance criteria in general. I'd actually start with a general question. Does it say anywhere in the climate change legislation that a scheme must be tested against local budgets?
No.
Can local budgets be found in the statutory climate change plan of the Scottish Ministers, section 35?
Well, I'm not sure. I don't think so.
No, they save us time, they can't. LE 114, if we can have that before us again.
Yep.
We've already had a look at S/1.4, the significance criteria, referencing the Scottish Climate Change Plan update.
Yeah.
Can I take you back in that document, please, to 3.18? It says, again, under significance criteria, an assessment of project greenhouse gas emissions against UK government or overseeing organisation carbon budget shall be undertaken and presented as follows. It's just to note and check if your comment that the table there at table 3.18 in the general LA 114 guidance, which references projected GHG emissions against relevant carbon budgets. In the third column, we see a reference to net carbon dioxide projected GHG emissions, bracket do something minus do minimum.
Yeah, it says that.
Apologies for jumping around the IEMA guidance. If we could have that in front of us, please.
Yeah, I've got that.
And the page reference, if you could turn to page 27.
Right, I'm on that.
The second sentence, I believe.
So is this an indicative threshold of 5%?
That's right. Could you've gone to where I was going to, where I'm taking you. Could you read out from an indicative threshold to the end of that paragraph, carbon budget?
It says an indicative threshold of 5% of the UK or devolved administration carbon budget in the applicable time period is proposed, at which the magnitude of GHG emissions, irrespective of any reductions, is likely to be significant. A project that meets this threshold can in itself materially affect the achievement of the carbon budget.
Are we in agreement that, just picking these sentences, that this section of the IEMA guidance provides a guidance note in establishing a threshold for material significance against the carbon budgets?
Well, I believe this one, if you start the paragraph, says a modification to this approach is required for the very largest scale developments. And I believe that's applying to, for example, large energy plants like, say, a gas energy plant, like you might have at Peterhead in Scotland, I believe is being discussed. Alternative, for example, one I've looked at recently, the Net Zero Teesside project in the UK, which is a large gas turbine power station, but with carbon capture and storage too. Those are the sort of projects which are being referred to. They're the largest scale developments, very largest scale developments. So it's large power installations, I believe they're talking about there. I don't believe it's applicable to the Sheriffhall scheme.
A threshold of 1% has been suggested.
Well, 1% is also banded around, but I think the IEMA significance, if you go, I think it's slightly further on in the document. It may be going back. No, so it's going back. Yeah, it's on the previous page. The examples of significance criteria, and in terms of alignment with net zero and the UK's trajectory or the Scottish trajectory within that, is on previous page 26. And that's the box I've quoted, box 3.
Yes, and Mr. Lansborough, in his recognition, also looked at that box and
he did. Yeah.
Thought the significance criteria for Sheriffhall was minor,
Yeah.
adverse,
Yeah. I mean, my very
fully
point.
consistent.
Yeah, my very point is that he did that on the basis of the information you have in the environmental statement and the information in the further information report. My very point is that when you introduce other contextualizations, which could be similar to the ones I've done, which I call indicative, then that minor adverse significance assessment becomes doubtful. As you introduce more information, you introduce it at a more refined level against local budgets, and more contextualization, and you start to see that the impact of the scheme is greater. And then also if you include the cumulative effects as well. And I would say on Mr. Lansborough's comparison, the cumulative effects, however you measure those, weren't in that assessment.
I think
so we have
the more accurate way. Sorry, apologies, Dr. Boswell, but the more accurate way of explaining Mr. Lansborough's assessment was that he took an approach which was entirely consistent with LA114 and is also rooted in the reality of the requirement to assess the impact of the Sheriffhall scheme, which requires a calculation of do something minus do minimum. As was discussed yesterday,
Yep.
the junction
Well,
is
I agree
there at the moment. That's a point between parties, and no doubt for
disagreement. I mean, I agree that that's what he did, and that's what I said. You know, the environmental statement, further information report, how that may align with LA114 and so on. But I'm saying that that has totally avoided going into the contextualization, which IEMA has the best practice guidance, is saying should happen. And as that contextualization hasn't been done, then when you look at the IEMA significance criteria, I don't think you're necessarily going to get the right answer. And I'm saying in this case, I don't think you do get the right answer. And I think we agreed on what Mr. Lansborough's done and the context in which he said that.
Yes, I think we have a clear understanding of parties' respective positions, which hopefully will assist the reporter in her task of reporting to ministers. Dr. Boswell, I was going to conclude by asking if we could agree that the reporter's carbon test, as you've described it, would more accurately be framed as to whether the Sheriffhall project, and I use that word intentionally, taking it from LA114, the Sheriffhall project will give rise to increases in greenhouse gas emissions, which will have a material impact on the ability of the government to meet its carbon reduction targets in terms of the 2019 Act. And I go on, and that assessment requires to be undertaken with reference to the statutory climate change plan update.
Look back to what the reporter originally said. So the reporter said whether the proposed scheme would be in contravention of the Climate Change Scotland Act 2009 and the Climate Change Plan update. So can you say how you're saying that might be rephrased?
more detail in my formulation. Will the Sheriffhall project give rise to increases in greenhouse gas emissions, which will have a material impact of the ability of the Scottish Government to meet its carbon reduction targets in terms of the 2019 Act, and that assessment requires to be undertaken with reference to the statutory climate change plan update?
Which will have a material impact on the...
I'm quoting from LA 114, there's no surprise there, will have a material impact on the ability of...
So you haven't told me which, I don't recognise it, which bit of LA 114?
3.20.
Well, I think you can rephrase that in your own submission if you want, but I have gone with how the reporter phrased it, and I don't see any reason to change that. That's what I understood the inquiry was working to.
I agree. Ultimately, this will be a matter for submission. I'm not sure it's entirely fair for the reporter, while she's in the room, to discuss what she meant in terms of formulating objections made against the scheme.
Yeah.
Thank you very much, Dr. Boswell. I have no further questions.
Thank you, Mr. Milne.
Okay, thank you, Mr. Milne. I propose we take a break until 5 to 11, just so I can go through my questions and probably take out a few that have already been dealt with this morning. And then you'll have a chance just to sum up any final comments once I've finished my questions. So if we break until 5 to 11 and start then.
Okay, thank you very much.
I make that 5 to 11. Dr. Boswell, are you back online?
Yes, I'm still here.
Okay, I just have a few final questions, really for my benefit and my understanding. I was mulling over the thing about the cumulative carbon emissions. And just so I kind of get to what I think is the crux of the nub of your concern, and I think it's because development has been included both in DM and the do something. And I think your position is that doesn't then, I suppose, show or illustrate the impact of developments that have not been built yet, but maybe built going forward from the opening year onwards, because they're assumed that they're all developed in the DM scenario. So therefore, is that what you mean by the masking effect?
That's correct, yes. And another way of putting that, which I think can be quite helpful, is that the developments which would come on stream have effectively all been put in the baseline as if they already exist.
So in a perfect world, and we don't have a perfect world, you would put them into the model in accordance with their own programming to then take account of their emissions in a cumulative assessment. But we don't have a perfect world. But if you had that information and all the programming information, that's how you would do it in a modeling world?
You do something like that, yes. I mean, I'm not. I mean, I think there's issues. I mean, I thought about this for a long time. That I'll say something which may be helpful on that. But I understand why traffic modelers have traditionally just done DS minus DM, and particularly if you're looking at the effects of a particular scheme on the traffic, and for example, in designing junctions, whatever, that actually is what you want to do, because you want to see the effect of that traffic intervention in isolation, if you like, in its own right, in the traffic modeling. So DS minus DM is the way to see that. What I think has happened is that the need to assess greenhouse gas emissions has come reasonably recently, and what hasn't happened is a re-look at how to do the traffic modeling in order to meet the requirement of the 2017 environmental impact assessment regulations to bring in the cumulative effects. I mean, it's more than just the regulations, in the sense that as we go forward and we realize the very, what I call the no degrees of freedom in the system for the emission space, it's very, very important that we actually know what's happening with the traffic system, with both the effects of schemes, traffic and transport interventions we may be putting in, and also other land-based developments, and indeed other transport systems which might be developing elsewhere in some cases. So that's why you want to do it, and that, I think, is what the European the authors of the EIA directive realized when they put in that need for cumulative assessment, and brought the regulations up to date for greenhouse gas emissions. And what we've missed with that really is the traffic modeling world catching up with that, But I understand why traditionally they have done things as DS minus DM, and the point is that it doesn't work in the context of the EI regulations as they are the 2017 ones. That sort of maybe added some insight to what I think's gone on and why we're in the situation we are in.
I take it from that you're thinking DS minus DM doesn't work in the context of a cumulative assessment.
That's correct.
But given everything we've heard, does it work in the context of assessing the emissions for the scheme, given that it's an existing road? So in that situation, to assess the impact of just the scheme, I think you said that just the traffic intervention, DS minus DM is the correct approach to take.
No, because there's now the requirement to assess the scheme with that phrasing in 5E of the 2017 regulations, Schedule 1A. If we refine that, so if you give me a moment. So I've gone to the 208-page PDF. And that Schedule 1A was on page 146. And going over to page 147, we have paragraph 5. And it says the description of the likely significant effects of the project on the environment resulting from. And it's got A is the existence of the project. And E is the cumulation of effects with other existing and or approved development projects. So when you're looking at the project, I understand that to say that you need to bring in the cumulative effect of the other developments too.
I see that from 5E, but 5F then says the impact of the proposed project on climate. So is that where you get the DS minus DM scenario? So almost it's maybe two separate things. The first one could be your absolute, but then if you look at accumulation of effects, but 5F is that DS minus DM because it's the impact of the proposed project, not cumulatively, but just the proposed project.
Well, that is a matter of interpretation. And, ultimately, I've said I'm not a legal expert. Ultimately, that would be one for the courts to decide. My view as a layman is that the cumulative assessment, the cumulative effects need to be included in the assessment. And as I say, it makes sense when you think about it.
Okay, thank you, Dr. Coswell. Most of my points were answered this morning, so I have
Okay.
no further questions. Are there
Right.
any final points you want to make in summing up very, very briefly?
Okay. I mean, coming back to what was discussed earlier, I said I had as a member of the effect of the discussion we've just had on the 2017 EIA regulations, I said I had a reasonable expectation. I reframe that I believe I have a legitimate expectation that the 2017 EIA regulations would be fully aligned to, given, everything we said about that the environmental statement was saying that's what its intention was to do. So that was the first point. On the HA207, I wonder if we could go to that again, please. I'm sorry, I've forgotten the number for that. It was one we had open, yes. Well, we had open with Mr. Elliott earlier in the week.
I think it's CD 4.001.033.
Okay. If we go to page 17 on that, can we check that it says regional impacts there? Those two versions of the documents, I think I'm on the version which is the CD number now.
My page 13 has got a heading regional impact just before paragraph 3.20.
That's exactly where I am too. That's good. Thank you. So those were the ones which we've just agreed. I've agreed with Mr. Milne. Those regional impacts, the screening criteria there, those were the ones brought into the original greenhouse gas assessment. The second bullet is a change of more than 10% to the number of heavy-duty vehicles. And the assessment 2 criteria is a change of more than 20%. So we are seeing Mr. Elliott's alternative method has doubled that. Well, I know the heavy duty vehicles aren't exactly the HGVs because you also have buses in and so on in there. But it's changed that screening threshold. And
sorry to put in, is it not changing it in a more prudent way? Threshold, making it a wider margin rather than the 10%. So it's not changing it in a cautionary way, unless I'm misreading it.
Well, because it's plus or minus, it depends, I think. But it's a change.
Oh no, because it's plus or you're saying plus or minus 10, so that could be 10% less or 10% more, up to 10% less, 10%
Yeah.
more in accordance with HA 207-07.
Mm.
But if we're saying plus or minus 20%, your parameters then 20% less, not 20% more. So it seems that's a wider band than the plus or minus 10%, therefore it should capture more.
Well, what I've said is we're not exactly sure what would happen. I think it's quite difficult to
I don't want to get into that. I'm just asking for your view on whether my interpretation of that as the plus or minus 20% is a wider band or than
Well, I think
what's in.
you have to run you have to run the sensitivity test and see the answer, because I think this stuff is not straightforward. So I wouldn't say I could answer that question. What I am saying is that I still say we should have had the sensitivity test done with that screening criteria as a sort of starting place to see whether the other the study area actually chosen, how it compared. We don't know otherwise.
Well, we have gone over this, and this is meant to be a brief, just picking up points. I understand your position on what you think is lacking, and I've got the sensitivity test from the promoter.
Yeah, that's the position. I just wanted to look at what I said about there will still be emissions at Sheriffhall at 2045 yesterday, just to clarify that. I wonder if we can go to the element energy report.
Ma'am, I would just ask if this has come out of the cross-examination or if this is an attempt to provide more evidence in chief, which obviously wouldn't be fair on the promoter.
Okay, it's clarifying the statement I made because it wasn't clear. So I suppose it does come into that.
So at that point
I'm
that
happy to take that if you want. I mean, I made the statement yesterday.
what was it the point that the promoter, you'd interpret it as the promoter saying there'd be no emissions at Sheriffhall in 2045?
Yes, and
I made the point that I thought it was a DS minus DM situation, so the scheme is producing less emissions than had there been no scheme.
Well, the emissions, when you look at those DS minus DM figures, they go to 2043. And if you take them on to 2045, they're very close to zero. Maybe that's what was meant. They have progressed them on, I think, in one of the figures in the OIR report. So they are, I'm not disagreeing that those DS minus DM figures are tending to zero. But I was talking about the absolute emissions would be greater than zero.
Okay, I get that from your evidence that it's greater than zero because you've assessed in your indicative contextualization tables and your additional evidence. And I can see that you're saying that by 2045 there's still emissions. So I get the difference.
Okay.
And I think the difference is derived from the fact that you do absolutes and the promoter's done a DS minus DM. So that's where difference is created.
Yeah, and the promoter has actually put those numbers in. I mean, I'm getting all my numbers from the promoter, so they are the promoter's numbers. And I mean, if you go to assessment 2 in the further information report, oh yes. Here we are. So it's page 185. bottom one, 85, the future year 2043, which is only 2 years off net zero, still has 81,295 tons of CO2 in the do something.
Yeah, no, I can see that.
So that's the absolute figures. That's what I'm talking about. But the point I was making yesterday was slightly different, actually. I mean, that's from the evidence in the environmental statement. It was possibly more a thing about policy delivery, but we can leave that as it's additional evidence technically, I guess. But I wanted to clarify, because I was sort of talking about the actual fleet proportions of electric vehicles and things. I didn't make the point very clearly, but I'm happy to leave it.
I think we can probably leave it based on what I've got.
Okay. Thank you very much. That really is the end of what I have to say, I think, then.
Thank you, Dr. Boswell. That does bring your evidence to a close, and we can move on to Dr. Nash. I'll just give you a couple of minutes just to move over here, take your laptop, whatever else you need, and then we can kick off with your evidence.
Thank you, Mum. Before I do my evidence, I asked when I was cross-examining Mr. Elliott about if Transport Scotland could disclose whether the update to the SRM12 model, including the did in fact meet the 20% per kilometre reduction target over the region or not. And I apologise for missing the inquiry for a few days, but I wondered if there'd been an update on that.
No, I don't think there has been an update on that. I don't think I've specifically requested it.
No, Mum, you didn't specifically request it, but there was some comment around it, so I was just inquiring.
Okay. Okay, well, welcome, Dr. Nash. As I said to other witnesses, you can either choose to read sections of your practition. Most witnesses have read maybe the introduction and conclusions. If you want to make any other opening submissions, remarks, updating your position on what you heard from Mr. Elliott, you can do that. And then we go into cross-examination. And then I might have a few questions on the back of that, depending on what comes out, what you're saying and what Mr. Millen covers. And then you can make some kind of closing comments based on the evidence you've given.
Thank you, Mum. That's fine. I think I'll just take my precognition as read. That's okay. And I have a few. I want to address the different sort of sections of that in turn, and a few updates based on Mr. Elliott's evidence I'll get to as I get to each section. That's okay. So, if I may, I'll start with the local modelling, which is mainly section 4 of my precognition. Thanks to Mr. Elliott for clarifying about the 2024 versus 2027 issue, and that was to give some headroom for traffic growth in their modelling. And so I'd like to withdraw the claim in my second paragraph of that section that this is an error. So it's clearly just something that didn't come across to me in the reporting. So that's clearly not an error. Thanks for clarifying that. Then Mr. Elliott and I had an exchange just before lunch, I think, about the day-to-day variations in the traffic flow. So my reason for asking about this was mainly trying to understand what the typical variations in traffic were in order to support the claim that I make in the paragraph 5 of the precognition. And Mr. Elliott said that in his general experience, not specifically for this junction, fluctuations from weekday to weekday were about 5 or 10%. And so the 3% difference observed on the day of the traffic count was well within the sort of typical range. So it's not like a particularly unusual day or anything, from his general experience. And given that the local parametrics model can handle only a fraction of 1% increase in the flows reaching it, and that's given in the traffic modeling assessment report table 9.2 and then discussed in paragraph 9.4.11 of that, you'd expect around about 50% of days in real world traffic flow conditions to have flows greater than what the modeling can handle. And really, what the point I'm trying to make is that the failure of the local model to give reliable predictions for this common scenario really does undermine whether the results are useful or not in determining what on the road conditions will be. That's about all I wanted to say about the local modelling. So turning next to talking about induced demand, which would be section 5 of my precognition. So we heard about how the capping of additional traffic levels at 25% of this additional or induced demand in the opening year of the scheme, at least in peak periods, was due to the failure of the model to produce valid results. And this is not a prediction at the point when the local network reaches capacity, right? This was purely, as I understood it from Mr. Elliott's evidence, purely a failure of the computational method rather than a prediction about reality. So if I'm being cheeky, Ma'am, I apologise. I'd just like you to bear that in mind whenever you see a claim that it's at capacity in the promoter's evidence, that this is somewhat
So
dubious.
it's like model capacity as opposed to real life
Yes,
capacity.
exactly. So it's the model fails beyond that point, but that's not a prediction about whether the junction is at capacity or not. So the promoter's shown that the forecast induced demand at peak time for the opening year is small, but I didn't see any evidence in the reports around the traffic modelling about future years. And as shown by the report I referenced in the first paragraph of my section 5, the one from the Transport for Quality of Life report assessing various road projects in England, most road schemes do in fact experience more trips than was forecast in the modelling coming up to it. And so I don't think there's any evidence presented that this scheme will be any different from a typical scheme. And further, this scheme will be used to justify further car-dependent developments across the region. So we know that the local authorities are predicating parts of their local development plans upon having the capacity at Sheriffhall to do this. And these developments are not modelled in the SRM12. Only those developments which are already confirmed and likely are accounted for in the modelling that goes into estimating the future demands experienced on the road network. Next, I'd like to talk a little bit about the regional modelling and active travel, and this is around section 3 of my precognition. So the second paragraph of this, I'd like to modify my argument slightly based on the clarifications from Mr. Elliott. So I do agree that the GB-wide national trip end model includes some sort of accounting for walk and cycle modes, and that this will therefore reduce the number of trips using other modes, so car, public transport, and so on, and that this will then filter down to the national transport model for Scotland and then the regional SRM12 models. But however, these models cannot show any changes in the mode share from the NTEM because they're fixed a priori. So Mr. Elliott explained about how if travel costs go up for a particular route, trips might mode switch to a different mode, they'll reroute, they'll displace to a different destination, or maybe be abandoned entirely. And so that effect is not covered of giving the ability of trips to switch to active travel in response to rising car costs. So if trips are abandoned in response to the rising costs, they're removed from the economic benefit assessment. Whereas if they were to become walking or cycling trips, the benefits of that can be accounted for instead of being a cost in the economic assessment. So really, the priority given to motor transport in the modelling in terms of considering how to create a well-functioning network is a very stark contrast to how active travel is treated. Okay, so a few points around the targets of reducing car kilometres. So that's section 2 of my recognition. So I think we had some evidence from Mr. Elliott that the updated SRM12 version 2022 modelling reached the 20% reduction in car kilometres target. It wasn't clear to me whether that reaches it over the region or whether considered across all regions in Scotland it reaches the target. And since the route map for reaching the 20% target, that's the core document CD-005-024, that makes clear that rural and island communities will have a much harder time reaching the 20% target. And so the expectation would be that they reduce their car usage by less, and that means there's a mathematical requirement that other communities will have to reduce by more than 20%. And so the South East Scotland region includes a large fraction of people in towns and cities and so on, and you might reasonably expect that they will need to reach a greater reduction than 20% in order for this Scotland-wide target to be reached. So if the SRM 12 update only reaches 20% in 2030, it will put the wider national target at serious risk of being missed. And the route map also makes clear that the relatively longer journeys make up a disproportionate fraction of the total car kilometres travelled. And that's kind of obvious. If you're travelling 50 kilometres, one trip contributes a lot more than if you go 5 kilometres. And so we've heard about how Sheriffhall is on the strategic road network, and these will typically be longer trips. And so these will indeed have to be reduced by a significant fraction, maybe not 20%, we don't know, in order to achieve the target. We also heard that Mr. Elliott no longer claims the modelling is consistent with the City of Edinburgh Council's target of reducing resident car kilometres by 30%. And so we've got no evidence, I think, in front of the inquiry about what fraction of trips through Sheriffhall are by Edinburgh residents in their cars, but we all know that it's going to be significant. Whether it's 5% or 50%, you'd have to look at trip surveys and so on. But if this fraction is reduced by the 30% target, then that means that the revised estimates from the SRM 22 are likely to be unreliable, and therefore an overestimate of the number of trips through Sheriffhall. And we've seen that, changes of just a few percent can be enough to totally change the congestion properties of junctions. So, reducing the number of trips should result in reduced congestion and therefore journey time savings, making the need for the scheme much less. And really, that's about all I want to say. I mean, we're facing a climate emergency. Can we please act like it? Can we make decisions acknowledging that honestly? Thank you very much, Mom.
Thank you, Dr. Nash. Mr. Millen, do you have any questions for Dr. Nash?
Thank you, ma'am. Just two questions. Good morning, Dr. Nash. You made reference, I understand, to the campaign for the protection of rural England document, which was lodged on behalf of SHU.
Yes.
Now we can go to that if necessary, but I wonder if you would like to agree with me that the schemes highlighted by CPRE are not comparable to Sheriffhall, which is a targeted infrastructure intervention to a grade separate in the existing junction.
They're not the same. I agree that, but comparisons can certainly be made as a general principle for road upgrade schemes.
And the second point that I wanted to raise with you was regarding your comments about the unreliability of the model. There was obviously a great deal of discussion with Mr. Elliott in his evidence around the reliability of the model. Do you understand that it is the promoter's position not that the model is unreliable, but that the road network is unreliable?
I don't know exactly what the promoter's position is.
Well, that's the promoter's position. It's not the model that fails because it's inherently unreliable, the model. It is that the model reaches the point that reflects the reality of the road network having failed. There appears to have been a significant misunderstanding between the parties.
Sorry, Mr. Mullen, could you say that again?
It is not that the local model is unreliable, but that the road network becomes unreliable.
So are you claiming that? Sorry, I'm not commenting on what the promoter's position is. I understood that Mr. Elliott agreed that the local model became unreliable when loaded up with 25% of the additional demand.
Reflecting the reality of the road network. That's why the model became
Which reality are you talking about? Are you talking about today or when the traffic counts was done?
Well, Mr. Elliott's evidence was the forecast year, 2024, when the road network, specifically the Edinburgh City bypass to the west of Sheriffhall, reached capacity.
I understood that the city bypass west of Sheriffhall reaching some sort of model capacity was the way in which the model failed. So I'm finding it hard to talk about reality when we're talking about 2024 and we don't know what the conditions will be.
This is the nature of forecasting.
Yeah, I know, but we don't know what the reality of 2024 will be, especially because the scheme's not going to be ready then. So I'm finding your choice of phrasing the question difficult to answer.
Thank you very much, Dr. Nash. I have no further questions.
Thanks, Mr. Mill.
Just on that last point, and I did discuss this with Mr. Elliott. My recollection was that it was the congestion to the west that causes the local model to be less reliable for the scheme. This question. I kind of get what Mr. Mill's saying is that the road network is unreliable. And we know that because you can go to Sheriffhall on different days at different times and have a completely different experience.
Certainly, yes. But
I guess what the model maybe doesn't reflect, and maybe you'll want to comment on this, is driver behaviour post 2024. So just because the model can't function because of that congestion doesn't mean necessarily in reality the road network won't function.
yeah, so it's difficult to predict, right? I mean, we're trying to say, is the model a true reflection of reality? Is it a true reflection of driver behaviour? And obviously it's not, but one would hope that it's a good approximation. So I'm not saying it's not, right? But I had understood from Mr. Elliott's evidence that it had reached a point where the modelling itself was unreliable, and therefore its predictions about what was happening could not be counted on either one way or the other. And I think it's worth noting that the base scenario was reliable under this criterion up to 2027, whereas the design scheme with the scheme was unreliable even in the opening year, with the very small extra amounts of traffic and the reassignments of the traffic behaviour from place to place, right? There were the changes of flows on the different links in the north-south direction and so on. I think it's that difference between the model's reliability and its predictive power. Your model needs to be reliable to have any predictive power as a sort of general principle. But the modelling used in this case failed, and therefore the fact that it's failing isn't a prediction about capacity. It's merely saying the model failed because the other one was already showing at capacity in the base scheme case, I think.
In your precognition, it's section 2. It's the 5th paragraph. And it's just so I understand what you've got here. And it's about reducing car kilometres. And you say with cars making up 76% of junction users in 2017, which I think was like the traffic counts that were done, one would naively expect a 15% reduction in vehicle numbers by 2030. But why are you saying 15% reduction by 2030?
Because the car kilometre reduction target only applies to cars, not HGVs and so on, and goods vehicles and so on. So the traffic count data indicated that the total flow through the junction, 76% were cars. And therefore you reduce that by 20%, you get a reduction in the total vehicle flows of 15%. So I'm sort of partially agreeing with what Mr. Elliott said in his precognition about goods and so on will still need to be moved through. And so 20% car kilometre reduction does not mean 20% vehicle reduction. And I totally agree on that.
I totally get that point. And on the point you're making about the model not, how do you phrase it, is that modelling of the active travel, the walking and cycling, and therefore not capturing the benefits of that. But it doesn't do that. Overall benefits of the scheme could be higher if those benefits were able to be monetised.
It could be. I mean, it's a more general point than specifically, is this a good scheme or not, right? It's without having the option for trips to displace to other modes, you may not see a true reflection of what the outcomes will be. So this could be an argument for or against any individual scheme, and it's hard to say. So, for example, if everyone just decides to walk because the traffic's so bad at Sheriffhall and it stays at the current level of congestion, then you still get the economic benefits of those.
I have no other questions because you dealt with them in what you said at the start. Are there any final comments you want to make in summing up based on what you said today?
No, I tried to pick out what I felt were the most important parts in response to everything that's been said over the last week and a bit. So I've got no further things I'd like to say. Thank you, Mum.
Thank you. Thanks for giving your evidence today. So that brings Shu's case to a close.
That's correct, ma'am.
And so that brings all the evidence for the inquiry sessions to an end. So really now thinking about post-inquiry actions now. And we've discussed both legal submissions and closing submissions. So before I set a timeline, I just wondered parties' views on, is it possible to separate your legal submission out of your closing submission and do a cross referral in your closing submission?
The promoter will do whatever you find to be the most helpful, but given that the facts and the law are so intertwined here across climate and equalities, which of course have been raised, although not discussed much in the oral evidence, given matters are so intertwined, the promoter's preference would be to deal with matters in the usual of the objectors setting forward their entire being provided with an opportunity. I would add, with Boswell having expressed concern about prejudice, not knowing what the promoter's position is on the law, the promoter's position on the law is as stated in the overarching report. It doesn't take the form of a legal submission, but there should be no surprises.
I'm not expecting any surprises from your case so far. But on reflection, my preference would have been for parties to comment on the legal submissions of each other's other party, but not the closing submissions. And that's why I asked if they could be separated out. And I do accept everything is so intertwined and linked. I appreciate it's a difficult thing to do. And if I go down the line of parties commenting on legal submissions, I would have given ideally the swap at the same time, but if that's not possible, then I would like to give Shu an opportunity to comment on the legal aspects of your submission, but with Transport Scotland having a final comment, to be fair to Transport Scotland. But it kind of elongates that process just slightly. I think that's okay. I mean, the report's not going to be written in a day, so I think we can accommodate that. But I think that's the fairest. So parties can comment on the legal submission, but I don't want commentary on the other party's closing submission. That's for the party to draw together their evidence and what they've heard at the inquiry and their final position on the case. It's not new evidence, so I don't want any comments on the closing submission at all. I want comments on legal submissions. So thinking of timeline on the basis that it'll all be done together. I appreciate there's a half term coming up and there's things like that. So initially I was going to say 3 weeks for Shu, both legal and closing submission.
Was fine.
Then 1 week after that, Transport Scotland's legal and closing submissions. You would have a further week from receipt of that comment on the legal submission from Transport Scotland. I will get Jane to send out a note of dates. And then Transport Scotland have a further week in response to your final comments, legal submission, to make any final comments. Maybe you don't have anything, and that's absolutely fine. And if you don't, you can just say that. If you've got nothing else to add, hopefully you have to add something. So that'd be 3 weeks for SHU, the week after for Transport Scotland, and that's closing submissions and legal submissions. The week after that for SHU to comment on the legal submission only, and a week after that for Transport Scotland to respond to any final comments from SHU.
I think I've got that, ma'am. But just to be absolutely clear, could you go through it again, please?
Of course. And I'll get Jane to send an email around with dates in it. So you've got the dates, but the general timeline is, so 3 weeks from today would be your legal submission and closing submission. The week after that, Transport Scotland puts in their legal submission and closing submission. Then you get a week from receipt of that to comment on the legal submission only. And Transport Scotland gets a week after that to make any final comments.
Yes, thank you.
Okay. What I have reflected on is whether I need to make the questions I want answered more specific than they were as set out in the pre-inquiry meeting note. Because obviously at that point, I hadn't heard all the evidence. And so I will reflect on that. So when Jane sends out an email, which will be tomorrow, so I can reflect, I will make it clear what the question is that I want a response to. So it's not going to be too different. It'll just be more detailed, potentially. But I just want to reflect on that based on what I've heard. So it's less general and more focused. And that'll be in relation to the 2 points that were in the pre-inquiry note. And that's just because we've got the benefit of the evidence and what we've heard. And it might be more helpful to make it more specific to answer direct questions than a general commentary. Now, kind of heard what the party positions are, and we kind of just distilled it down a little bit. So when Jane confirms the date, she will confirm the questions, and the timeline will go from tomorrow rather than today. So I'm not prejudicing anyone's period of 3 weeks or 1 week, whatever else. So does that sound like a way forward?
Thank you, ma'am. That is understood. That's absolutely fine with the promoter.
Likewise, that's fine.
Okay, are there any other final matters anyone needs to raise at this point in time?
No, ma'am, nothing else from the promoter, just to thank you for the conduct of this inquiry and actually managing to get things wrapped up for lunchtime on Wednesday. Thank you.
Thank you, Mr. Milne.
Likewise, ma'am. I think it's been a very fairly heard inquiry. And as objectors in our position, we really appreciate that we have the right to come here and make a case. So thank you very much.
Thank you, Mr. Walker. And I would like to say thank you to all the participants for your conduct of the inquiry, all your preparation beforehand, and the fact we got through, because it looked a bit doubtful last week we were going to get through. So I think we made really good progress. I'd also like to thank Jane, the case officer, for obviously her patience in allowing us to get to this point, particularly with the documents. Actually, it's been, apart from that slight glitch with the regulations, it's been pretty smooth with the documents, given how many documents there are. So thank you for working with her to get those done. Thanks, Callum. I've also got Ewan, who you would have seen on screen this morning, who's been helping back in the office to make sure we're still streaming live. And without the two of them, we couldn't have done the hybrid. And I think the hybrid's worked really well, actually. And and it has allowed Dr. Boswell to continue to take part in the inquiry. So it's been good. And actually, it's the first time we've done that ourselves. We did it once during COVID with external providers. So it was kind of a bit of a test case. But I think the feedback is positive, that it's worked well. So yeah, that brings the inquiry to close. So thank you all and have a safe journey home. And Jane will be in touch tomorrow with specifying the dates and the questions. Thank you.